We're going to talk about two things, guys. We're going to talk about earnest money because, as you know, uh, when I don't have to do a whole lot of prep for these calls, because I usually like to try and bring uh, things that I am dealing with as a broker. And I see that Nan Ellington's on the call. Hi, Nan. Thanks for being here.
Good morning.
Good morning. Good morning. I know that you'll be able to add some good dialogue with this today, because we're going to talk about earnest money and the issues that I have been seeing with earnest money. And we're going to talk about the temporary occupancy agreement and some issues I've seen with that document as well, and some scenarios that I want to make you guys aware of. So we have three market centers that are in what we call the hub. Okay. And the hub is a centralized MCA group, okay, that services the in-town market, the midtown market, and the Buckhead market. And so there have been a few challenges with because you can't just turn earnest money into your MCA. There's a process that it has to go through. And so the good news is we are making some changes to that, so that that's going to be handled at the market center now with the operations managers, who are really your MCAs in your office. And the hub is where all of the transmittal and more of the heavy duty things are happening at more of a centralized location. So we're going to talk about earnest money today and some issues that I've dealt with. Number one, with contracts that were written that really weren't great in terms of when to collect earnest money. I've had situations where earnest money was due on the same day that there was the due diligence ended, and earnest money was never collected. So let me talk to you a little bit about this whole topic in a conversation, because there's a lot of folks that don't understand the way it works with earnest money. Okay, so I recently had an issue where we took, this was over $1 million property. It was a $25,000 earnest money, and there were no due diligence days attached to this contract. It was zero due diligence, but the agent allowed the buyer to provide earnest money within 3 days of binding agreement date. Okay, so normally that might be okay, but it's really not okay, because they had cold feet the next day and never turned in the earnest money and terminated the contract. And so the seller should have received those funds, but because they were never collected, there was nothing to disperse. So moral of the story is, if you're going to take a contract that has zero due diligence or very, very short timelines, you better get a certified check or wire funds up front before you go binding on that contract, so that it isn't, we have those funds to disperse in case there is a breach. Okay, that was a real problem. And unfortunately, the selling agent in that scenario told our agent that they were not going to collect the earnest money. They were not going to pay the earnest money, or they had not collected the earnest money. And so what the contract says is that if the earnest money is not collected, then the buyer is given notice to correct and deposit the funds, and that if those funds aren't corrected, if that isn't corrected within 3 days, on that fourth day, the seller can either move forward with no earnest money or terminate the contract. So in this case, since we were told that the earnest money funds were not collected, that was the only outcome for this particular scenario. So first, I want to make sure if there's any questions about that. I only see two other agents on this call besides Nan and Pierce. Is there anybody else on the call that I'm missing?
Hey, Tom, I'm here.
Hi, Amy. I see Amy. I see Barbara Dyer.
It says that there might be some people on Facebook as well.
Okay. All right, good. Well, is there any questions about that procedure and process? So
No,
what I want you to understand is if you're a listing agent and you are taking if you're going to take a contract on your listing and it's going to have very little due diligence or zero due diligence, you really need to get certified funds before that goes binding. Otherwise, you're not going to have any recourse for your seller. It's like in this case where the buyer actually breached the contract because they had zero due diligence, all cash. So they didn't have the right to terminate the contract. But because we were notified that the earnest money hadn't been collected, then we really didn't have a choice other than just to terminate and move on. Now, if the situation had been a little different and they had not notified us that the earnest money had not been collected, then we might have an issue where we might be able to go after that buyer for that $25,000. Okay, so that's the key. The key is if you as an agent don't notify the other party that the earnest money hasn't been collected or it's late, then potentially the brokerage could be on the hook for those funds. So I'm telling you this to put the fear of God in you, to please make sure that you are collecting these funds and following up and making sure it's deposited. That is your responsibility as an agent. Okay. So,
Tom,
yes.
I teach that we are not investors. The contract changed to the economic downturn when the investors were making multiple offers and they weren't providing earnest money until one of them became binding. We are owner occupied. We should be providing earnest money with the offer.
I totally agree. When I was selling real estate years ago, I always, and this, times were different, obviously, but I always sent a copy of my earnest money check with the offer and also the instructions closing attorney to protect my commission.
Absolutely.
I can't tell you how many times at the last minute I get calls and there's a commission dispute at the last minute before closing, and that should not happen.
Well, and I also teach, and I've got a few agents that do this. The day you're writing the offer, print out the FMLS or Georgia MLS and circle the commission and make it part of the contract, because agents are changing the commission rate on FMLS.
Right. Yeah, that's a really good idea as well. All right, so let me tell you about scenario number 2. Amy, Barbara, any input from you guys? This is your own personal broker chat today.
Well, I just wanted to confirm, you're suggesting sending the instructions to closing attorney with the contract or after binding?
I would send it with your offer.
Okay.
And
if you're collecting a check, I would send a copy of the check with the offer. That's your strongest offer right there. Like, I am proactive. I've already collected the earnest money, okay? It hasn't been deposited yet, but I have it. So the minute you sign it, Mr. Seller, we're going to deposit these funds.
Okay.
When I do the class writing the winning offer, I said if the seller has 2 offers that are exactly the same, and one is going to provide earnest money in 5 days and one is with the offer, which do you think the seller is going to take?
Right. Absolutely. So let me tell you about scenario number 2 that I dealt with, sort of the same situation. So we had another buyer. This was our buyer, not our listing. And the buyer was to tender $30,000 in earnest money. Okay. Now, what happened here was they decided to terminate within their due diligence period, and the earnest money was due the same day as the due diligence period when it ended. Okay, you follow me? So earnest money's due the day that due diligence ends. So the buyer terminated. One buyer, there's 2 buyers, they're both out of state, and they're not going to give us the earnest money because they're terminating, and they terminated lawfully. However, the agent just turned it over to his contract to close person, notified the listing agent that the buyer was terminating, did not mention that the earnest money had not been collected, and dropped it. So the contract close person had a really difficult time getting in touch with buyer number 2. Consequently, even though they terminated lawfully, the signed termination to the listing agent happened 2 days or 3 days after it was supposed to have been turned in, after due diligence. We also did not notify them that the earnest money hasn't been collected. So this is a problem, because I expect that listing brokerage at some point is going to contact us, even though we spelled everything out to them in an email. I suspect that they're going to come back after the brokerage for that $30,000. That's potentially what can happen, because we didn't notify the other party, we didn't collect funds. If we had done that, the situation would be a little bit different. But that's not what happened. So when earnest money is not collected, our duty per the contract is to contact that other agent and let them know that we have not collected the earnest money. That buyer has 3 days to cure that default. And on the 4th day, if they have not cured the default, the seller has the right to either terminate the contract or move forward with no earnest money. Now, what seller in their right mind is going to move on in this market with a contract with no earnest money? Very few, if any. So the moral of the story is, ultimately, we can say, oh, so-and-so, the market center lost a check, or they didn't deposit the funds. But ultimately, it's your responsibility as the agent to make sure that those funds are collected and that they are deposited by the market center. Always a good policy to take a copy of that deposit and send it to the other party, showing them that we've deposited the funds. This is a big problem, guys. It's getting bigger and bigger and bigger because the market is moving so fast, and we're all moving so fast that we're not taking the time to do the necessary things that we should be doing to protect our client and our broker. So,
Tom, oh,
at some point, if we have to write a check because you didn't follow up, guess who's going to be eating that money? You.
Hey, Tom, this is Barbara, and I just
Hey,
want to
Barbara.
I want to add another comment, and I hope that your partner is doing much better now.
Thank you.
I would just like to also mention that with that earnest money those deposits and those checks, when you're sending proof over to the other parties, it's recommended that you not send a copy of your client's check, because that check has your client's confidential information on there. It has their routing number, it has their bank account number. Most of the time, it even has their addresses. So if you're sending proof to the other party that you have received the earnest money deposit, it's recommended that you don't send a copy of your client's check.
Well, when I said that, I mean, obviously, and I didn't say it, but you would have to black out the routing number and all of that on the client's check. But it's still good policy to always send a copy of it, but better policy to send a copy of the deposit.
Thank you, Tom.
Now, there's been a lot of conversation, and I think you're going to see this happening in the Heart of Atlanta group, where we're going to be moving more toward ACH and wire and not accepting checks. We had a discussion about this last week with the hub, and even though I agree and encourage wiring and ACH, because in Decatur, we just went to Earnest, which is an app, and I think we use that in South Fulton as well. And I've seen it in some other market centers, but nonetheless, at some point, and I'm like, well, we can't say no checks, because there are clients who still use their checkbook, like me. I use my checkbook. But the contract also says that we can, that check is an acceptable form of collecting earnest money. So we can't say no checks.
Correct.
But
and that Earnest Money app that we have in South Fulton, Tom, I love it. I love it. I love it, because as soon as they make their deposit, there is a selection in there where you, the realtor, can get notification as soon as their deposit is made. And that's generally what I use to send over to show that I have received the earnest money deposit.
Yeah, it's great.
It is.
And so I think we'll probably be seeing more of that moving forward in the Heart of Atlanta group. But, there's always human error that's involved in anything regarding, accounting. And I just want to stress how important it is for you as an agent to make sure that you are collecting and making sure that that money is deposited. That is your responsibility, okay? Because guess what? Like in the case of that $30,000, that admin, they're not on the hook for it. The agent is, and the brokerage is. So why would you trust something to an admin that might affect your license and your ability to sell real estate and make money? Okay.
Tom, I got a call from one of the agents that I trained years ago, and she goes, "Thank you, Nan, for making me do this." She was buying a house. They had a $75,000 earnest money check. She had the envelope and the check and filled it out, and she scans that into Command. And the office lost her $75,000 check. They found it the next day, but there was a little bit of a panic, and because the brokerage is responsible for that check if she turned it in, and she had.
Right. I think that's why Brett, our operating partner, is wanting to move more to ACH and wire transfers for the collection and deposit of earnest money. It's a little easier to track. Again, human error sometimes interferes in the best laid plans, but we certainly don't want to get caught in a situation like Nan just described.
Well, then, Tom, if we're moving away from checks, and you had said if there's 0-day due diligence, you want to see the cashier's check, with the offer, like how do we do that? Do they do that?
Well, now it's very easy for you because we have Earnest, and you can get those funds collected through that app. and I would just be adamant about that. We've got to have funds. If you're going to have 0 days due diligence, and just use the example I used. What if your buyer decides tomorrow that they're getting cold feet and they don't want to move forward? Then we don't have earnest money. We want the earnest money before we go binding. And I would be very firm about that.
Okay. I personally still like the checks. I've worked with enough older clients who just, they hand me a check.
Yep. I don't, listen, I'm fine with checks too, but
Okay.
collect it and make sure it gets deposited, especially with 0 days of due diligence. In this case, this was $1 million plus property, and I would have demanded that we had those funds sent to us via wire or ACH through our new app
Okay.
before I would bind that contract.
Okay.
And there's no reason in this case why that couldn't have happened. There were multiple offers on the property. Okay. So any questions about that? Let me talk to you about 2 more things regarding earnest money, and then I'll move on. Number 1, closing attorneys who hold earnest money. I don't understand why agents don't get this, but they don't. There are 2 forms that must be signed and filled out, the F510 and the F511. I generally will get one or the other, okay? And it says it's clear on the top of the form that both forms must be signed. So I don't understand why agents don't get that. But if you're going to have an attorney hold the funds, number 1, the agreement needs to be signed by the attorney. And number 2, the closing attorney acting as the holder is the second document that both parties sign. Now, what I have found is that most closing attorneys that hold earnest money, if there's a dispute, they will not do a 10-day letter. They'll interplead the funds. Okay. And to me, that doesn't make sense for you or for your client, because whoever's at default or whoever's due those funds, they're not going to get a penny, because the holder of the funds, if they interplead them, has the right to deduct court costs, attorney fees, all kinds of things in order to interplead those funds. And so a $10,000 earnest money check, you could be going to court to fight over $500. So just be aware that if a closing attorney is holding funds and there's a dispute, more than likely it's going to get interpleaded. So nobody's going to get anything. And number 2, make sure if you are agreeing to having an attorney hold the funds, make sure both of those documents are signed and uploaded into your command file, because it's going to get kicked back if not. Okay. So the last thing I want to talk about is the fact, and a lot of agents don't understand this either. I know Amy and I know Barbara do, but I'm just going to hit it real lightly here. And hey, Daniel Bledsoe's joined us. Hi, Daniel. So what happens if there is a dispute and we can't get one party, generally it's the seller, to sign off on a unilateral termination? The holder of the funds has the right to disperse those funds based on a reasonable interpretation of the contract. Okay. So just so you know, what that process looks like is that if a seller refuses to sign and a buyer, and I see this all day long, Nan sees it too. If we have a buyer who terminates during their due diligence period, or they terminate lawfully, whatever the case may be, and the seller just doesn't want to sign that document, then whoever's holding the earnest money has the right to disperse those funds based on a reasonable interpretation of the contract. we have to send out what we call a 10-day letter to both parties, notifying them of our decision and the cause of our decision. And then then 10 days later, we can release those funds to whoever the funds are due. Okay. And in my 24 years in the business, I've never had to interplead funds. It's usually cut and dry. Sometimes it gets a little gray, but I've never had to interplead funds. And there was one time and I love to tell the story. One time I almost did have to interplead funds because it was a little gray. And both parties had attorneys. And I just said, attorneys, y'all can go to court and fight out over this. I've got the money. I have the right to take out my reasonable court costs, attorney fees, filing fees, all of that. And so you can go to court and fight over $500 if that's what you choose to do. And they reached a settlement and they decided to split it. So that's that. The second thing I want to talk about on this call today is there's two more things I want to talk about. The temporary occupancy agreement. I've had several issues lately where the seller was given temporary occupancy, and at the last minute, they weren't ready to move when they were supposed to move. And the agent only had as the penalty $100 a day. Now, guys, if you're going to let somebody stay in a property for 30 to 60 days, you better put some kind of number in there that makes them hurt. Okay? Because at $100 a day, if I need 2 more days to move out, I'm not going to be too concerned about $200. Okay? But if it's $1,000 a day, I might be more likely to get my act together and get out of that property. Okay, so just beware if you if the listing agent and you're allowing, and you agree, and the buyer agrees to allow if you are the buyer's agent and and that buyer agrees to let the seller stay in that property post closing, you better put a number in there that hurts. Okay. I wouldn't even put $500. I would put a minimum $1,000 for a holdover fee per day if they don't get out of the property. Okay. Any questions about that? I just wanted to bring that up because I've dealt with several issues in the last 2 weeks where the seller is not ready to get out of the property and the penalty has only been $100. I see it all the time. I've been looking at contracts in compliance, and I look at that temporary occupancy if it's attached as to the contract to see, and I can't tell you how many agents just put $100 there. So just take that under consideration if you're working with a temporary occupancy and it's your buyer who needs to get into their property because they've already closed on it and the seller's not ready to get out. You better put a number in there that's going to hurt.
That's the same thing that Seth Weisman said too, Tom.
Well, it only makes sense, because like I said, I mean, $100 a day, if I'm moving and I need a couple more days, what's $200 at the end of the day? Not a whole lot. But if it's $2,000, then yeah, that starts to add up really quickly. Okay, guys, so the one last thing I want to go over with you guys today, and then I'll open this up if anybody has any topics they'd like to discuss. We'll be happy to do so. The new contract has a clause that I was not aware of. I will admit I wasn't aware of it. But it was brought to my attention when I spoke with an agent from the West Cobb office last week. And it was a VA loan. And what the contract says now, if there is a conflict between the special stipulation, because, we're getting all kinds of stipulations that, we'll pay $5,000 over the appraised value, so on and so forth. But the contract now says if there's a conflict with the amendatory clause stands. So, I had not really caught that until we had this discussion. And that was brought to my attention. And so I just wanted to share that with you, that if there is a conflict in the contract between the appraisal on the amendatory clause for a VA or an FHA loan, then the amendatory clause is going to stand, and everything else will be deferred to that. Does that make sense?
And can I add one more caveat to that, Tom?
Yes, ma'am. Please.
Because I sit on the forms committee, and another thing with that amendatory clause, if you are past your due diligence period for that appraisal, with the amendatory clause, if the property doesn't appraise, they still will get their money back.
Absolutely. And that's always been the case. But now, if there's a written stipulation, the amendatory clause is going to preempt that. So I just wanted you guys to be aware, if you are a listing agent and you're taking a VA or an FHA loan, just be, remember that when you're looking at all of the factors that are in that contract that's being presented to you.
Tom, I was listening to Seth Weissman several months ago about the FHA, and he said even if the seller reduces the sales price to the appraised price, the buyer still doesn't have to buy it, which
That's
is
right.
really, really kind of amazing. I mean, it woke me up and I was like, whoa.
Yeah, it's up to the buyer at that point, because they're not penalized. Because it's a government program, they're not going to be penalized. But one more thing I want to talk to you guys about, and then I'll let you go, or you can open up the floor to anything that you have. I have seen a lot of issues regarding a special stipulation that says the buyer will agree to pay, and I'm using this as just an example, $4,000 over the appraised value. Okay. And the listing agent is taking that. Okay. And what I've seen is that the appraisal comes in way low. And even with that $4,000, the seller doesn't want to sell the property that low. So please, as a listing agent, put a cap on that statement. In other words, if somebody said to me and presented an offer, the buyer will pay $4,000 over the appraised value, and they left it that way, I would add or counter that the appraisal must be X amount, or we will have to renegotiate terms, okay? Because we're probably going to be getting in a lawsuit over an issue where one of our agents took a special stipulation like that, and the seller's like, I'm not selling it that low. And it was our mistake. We should have put a minimum that it must appraise for at least this amount. And we didn't do that. And I see this all the time. I've dealt with it many, many times. So I just want to share this with you guys so that you will be better informed about that. And then let's see, was there anything else I wanted to talk to you about?
Tom, I'm helping
I think that's it.
agents.
Go ahead, Nan.
with that special step, because I say to the listing agent, is it priced right? Will it appraise for list price? And so I put list price as the floor. Property must appraise for at least the list price. Buyer and seller agree to renegotiate.
Right.
And then if they're going to give, any money, it's beyond the list price, not to exceed the sales price.
Yep. I totally agree. Totally agree. Okay, guys, is there anything else you guys want to talk to us about before we end the call today?
I did have an interesting situation with temporary occupancy. It was our seller, the buyer gave them 30 days, and she decided she wanted to move in before that 30 days. And so she talked to an attorney, and the attorney said she could move in with those people, that the sellers didn't have to move out. The buyer can move in. And I was like, no, you can't do that.
No, they can't do that. That's why they have a temporary occupancy agreement in place.
Yep.
All right, guys. Well, I appreciate you, Amy, Barbara, Daniel, Nan, for joining me today. I guess our next call will be in 2 weeks, and we look forward to seeing you there. Thank you so much. Appreciate it.
Thank you, Tom.
Thanks,
Thanks,
Tom.
Have a great day.
You as well.